see we got people signing on. Thank you so much for being with us today. And thank you for your patience. We were having some technical difficulties the first few minutes. So I hope everybody's still here that was planning to be here. I'm Lisa from the Law Library, and with me is Joshua Tucker, our speaker today. I've been looking forward to this. I've known Joshua for years, and he's going to do a great presentation today. But yeah, we had a little stress at the beginning there with some technical problems. Okay, so I just have a few housekeeping things to say before we get started, and while Joshua gets everything set up here. This is a CLE presentation today, and you will be getting a certificate for your participatory CLE credit later this afternoon if you're signed in on the Zoom today. And I verify that with the Zoom report. And again, that's for those of you that are watching this live today. If you're watching this later on YouTube, there is no participatory certificate. The State Bar has a log that you can use to keep track of your self-study credit. Q&A, this will be a participatory session today. You will be able to post questions. We've got a lot of material to cover, but hopefully we'll get to some of those at the end. Just be sure to use the Q&A function here to post your questions. Oh, I see there's somebody who's saying they can't hear me. Yeah, I'm not sure what the problem is. Hopefully some of you can. And I see somebody's raising their hand. Okay, all right. So it sounds like, Dan, you can hear now. Great. Hopefully we're not still having technical problems, but we're going to carry on. Okay, great. Thank you, Keith. Thank you, Leslie. Okay, all right, where was I? Oh, Q&A. Yeah, be sure to use the Q&A as some of you just did to post any questions that you have. And there will also be a survey at the end. So if you can take a moment to take our survey at the end, we appreciate that. If you're still looking for CLE credit, the Law Library has 2 more participatory webinars happening. One of them's tomorrow, the 26th, and the other one will be on the 30th, which is Tuesday next week. So check our website for information if you want to sign up for those. And with that, I've taken up enough time. I'm going to turn things over to Joshua.
Thank you, Lisa. I appreciate that. Welcome, everyone, today to Avoiding Bob's Blunders, Effective Residential Tenant Selection Strategies. My approach is a narrative approach to presentation rather than just slides and rules, using an exaggerated version of a not-so-good landlord. We call him Bob here. You can see a picture of Bob in the background here and some very upset tenants. So we're going to use him as a springboard for learning on what not to do and how to approach matters in any facet for selecting tenants. So there you go. My name again, Josh Tucker. I have a founder of Local Realty Law, focus in the area of real estate, in a variety of areas, anything real estate oriented, especially in the matter of advising landlords in residential and commercial matters. Let's go on. This is how to find me. You'll have that in your presentation materials. So let's get started here. So again, Bob's world, misguided landlord, and his style is more of a no plan approach. He just sort of goes along as he sees fit and sort of snubs his nose at the rules and the requirements. So this is the opposite of what I want everyone here to do. So you'll see here as we go through it, what Bob does, and then we would want to do what would Bob do and do the opposite. Just so you can see here, you'll see Bob here in some of his various forms. We call him sort of a greedy landlord, or in a way, slumlord in some sense, but someone who isn't thinking of the rules or how to approach this from the very beginning, gets himself into trouble in a variety of ways. So I want everyone to review and see, as we discuss it, what he does and how we could do better. You'll see this throughout, some of Bob's sort of quotes and thoughts on things. One of the things that's very important in the beginning, if you're going to be choosing selecting a tenant or tenants, this could be in a variety of areas, whether it's a single family home or apartment building or in any facet, you got to have a plan. what am I doing? What's the target audience in some sense? How much am I charging for rent and why? All of these things need to be planned ahead of time. You don't want to fly by the seat of your pants. You don't want to uh, see as you go. You'll run into problems, not just legally, but contractually, and also you may not get what it is you're intending to do regarding tenants. So here we talk about Bob winging it. We do not want that. So here we got Bob and his haphazard approach. That's not what I want you to do. The approach here for anyone choosing or selecting a tenant is a very structured, well-defined plan as much as you can, and that include a variety of things you'll look at. You do not want anything inconsistent or arbitrary, especially because you want to treat all tenants equally. You don't want to have certain rules apply to some and not others, and that'll likely happen if you don't have a plan from the beginning. Like I mentioned earlier, what's the rent? Am I going to do month to month? Am I going to do a lease with a fixed term? You want to treat, and we'll get into more detail later, but you're going to want to treat all tenants equally, regardless of the source of their income. For example, even if it's you don't want to treat a college student differently from someone else. You do want to obviously look into the background, which I'll talk about later, but everyone needs to be treated equally, and that'll come into hand later also when reviewing the records you have. So you're going to want to keep track of your plan and how you implement it. So if there's a concern later by a tenant or something you did, you can show what it is you in fact did do and that you in fact were fair across the board. So here we go. I'm going to explain something that actually happened with a client. So we'll call this Bob's blind bargain. This happened to a real client of mine. He thought he could, without really planning ahead of time, just submit a Craigslist ad and go ahead and get a tenant in his home. It's a single family home. Didn't have a plan regarding who the tenant was or what he was doing, how much rent, or the agreement he intended. Instead, just posted a hasty advertisement and did get a response. We'll call this person John Smith. And the person said, I could pay a few months up front. And obviously, client was very excited about that, but didn't do anything further, as we'll talk about through this presentation. Didn't do any background check or anything like that. And at the point when the potential tenant was supposed to pay, just sent a screenshot to my client. And without the client even evaluating it or determining whether or not he actually received the money, gave the tenants the key. So we have the Smith slimy scheme here. This is actually just a portion of the screenshot set by the potential tenants and showing the money. Doesn't show where it was sent or that it was actually sent to the owner, but they accepted that as is. It gave the keys and the tenant entered, and it turns out this was not, at least not to the landlord. Who knows where this money was sent, if anywhere. Obviously, a very knowledgeable tenant enters and turns it around into a dog-friendly Airbnb. And so now, at this point is when, landlord calls me and says, hey, what do I do? How do I get them out? They're destroying my place. I'm not sure what to do. And now we have to go through the unlawful detainer process. But had landlord actually planned from the beginning and gone through a vetting process, this likely would not have happened. So here we have our dog-friendly Airbnb, and then not only did client have to pay for an eviction, but had to pay to fix the place, because after leaving, obviously being dog-friendly did not end well with the actual apartment. Another very important element when you're renting to any tenant. There's extremely broad governing protection laws, anti-discrimination laws, state and federal, that will apply to all parts of the selection process, from the very beginning to advertising, through the legal terms of your rental agreement and what you do. So that's why it's very important that you plan ahead of time, so you can make sure, maybe show it to others or an attorney, or just to clarify that what you do is fair, and that you're taking all measures to make sure that you follow through and are not doing anything that could be deemed discriminatory, even if you don't think it is. So here, some of the key prohibitions we're talking about. We have fair employment and housing in California, and California fair employment housing under the California statutory, fair employment housing under the federal, also Civil Rights Act. And so the way you should think about it is, anything you're going to limit or make any kind of distinction among anyone when you're part of this process, you better have an exception, or there better be a good reason, or otherwise it's likely to be discriminatory. Because in addition to FEHA and the Fair Housing, we also have the Unruh Civil Rights Act, which also expand these into almost any category, age, gender. So it's very important from the beginning that you're careful and taking aim to not limit who you're selecting, or if you do limit, that there's a good reason for it, that's permitted by law. Here we have Bob, who sort of ignores that and just has sort of arbitrary and inconsistent standards. So that's not what you want. Here's a quote by our pal Bob. Well, not really our pal. We don't like Bob. He's not a good. Bob's just interested in money, and he's interested in greed and business. And obviously, it's exaggerated, but that's not what. It's obviously a business to some of you or many of you. Either you're going to be your retirement income or your sole business. You own apartment buildings or homes you're renting. Obviously, you need to take aim that in the business, what you're doing, you need to know all aspects of any business. And in this business, your compliance, you're dealing with the public, and specifically tenants who have many protections. So these are things you're obligated to know, even if they might seem complicated. So make sure that in that sense, you're getting help. We don't want to be like Bob here, just interested in money and doesn't really care. So one of Bob's initial faux pas here is his advertisement. He's advertising for single professionals only. I'm sure some of you can think, why is that wrong? And you could think yourself out loud, or think yourself why this is wrong. Think about that any kind of limitation, and I'll talk to you about a couple exceptions in a few minutes, is improper. You're permitted to advertise in certain areas. For example, if you're in a college area, you can advertise there, but you don't want to limit. So here we have Bob's, professional single professions only, because in his mind, they're the ones who likely can pay. But specifically, the government code does not, statute here does not permit that. And the same goes with, here we have Bob, where single family here, Tiny Tim and his animal, they're coming here, they're saying, we want to rent. Bob doesn't even permit them to submit an application. But note that there's many protections, including for familial status. So that's not permitted. You can't reject an applicant or a family because in your mind, you would like to have single professionals only. Now, there are narrow exceptions, just so you'll be aware. And so that's when I said earlier, if there's something you're going to do and it's outside of what you think might be permitted, or you're limiting or classifying who you're advertising to or renting to, there has to be an exception or permitted exception, or you're likely to be in violation of either state, local, or federal law. So in general, owners renting a room in their home can limit occupants in some sense. For example, if there's a single woman who's renting their home, they could select another person who's another woman instead of having to require anyone, because that makes sense and that's not necessarily discriminatory. But make sure your ads clarify why that is, so it doesn't look discriminatory. Another one is age restricting. There are senior communities that are under federal law, but under certain distinctions. So you could advertise, but you have to make sure that you're following the requirements, the statutory obligations for a senior community before you can do that. Before you would just say certain groups only. Are you in fact a authorized senior community? Here we go. Shared living is what I mentioned earlier, a preference for the same sex. Or you're renting your home, as long as you're still governed by discriminatory rules. You can't limit on families or race, gender, but you have more decision making as a single family owner occupied home. Okay, additional concerns. Bob decides to post and submit additional ads. And I mentioned earlier, age discrimination. Bob has a community apartment, but he's not a registered or authorized senior facility, and he just says retirees only. So a general ad cannot do that unless you're authorized. Bob also says no Section 8. So this is actually something I also get many times, people asking about, do I have to rent to Section 8 voucher? Well, the short answer is yes, in the sense that you can't say no based on the source of someone's income. You're allowed later, and we'll discuss, to investigate that a person does have the ability to pay your rent and has a job, but if they're getting income from another source, that's not really your concern. So you cannot say no automatically because it's Section 8. And in many cases, I'd recommend that you look into that as well, because that Section 8 is valid because you do have a group that is paying some or all of the rent. So you keep that in mind. Additionally, national origin, you can't limit saying, I want someone speaking English, or limiting where they're from. That's not permitted. So to, I guess, summarize, go over this. Inclusive advertising. So generally focus on the property features, not the tenant characteristics, unless there's a valid exception. Be careful, your advertisement, I said, can't be construed as discriminatory. If you focus on the property, then that's fine. Just make sure, in general, for business reasons, that your advertising is not only related to the issue of being discriminatory, but you're being fair, and you're also being clear that what you're doing is, in fact, what you have. Don't advertise something you don't have. If you don't say pool when you don't have one, or amenities you don't have, is your price fair? You're okay, again, where you advertise. You advertise in a college newspaper because that's where most likely you'll get your tenants. That's fine. And again, also in the ad, when I say state all legal non-discriminatory rules, what I'm meaning is if you're saying no smoking, which is permitted, or if you're clarifying regarding pets, that's also permitted, but you want to state that up front. So anyone that doesn't fit within that category, and that's permitted, knows that that's going to be a limitation. So I do see a question, but I'll get to all the questions at the end, just letting you know, so don't worry. See, now just sort of here we have Bob here and his way he picks tenants. He wants the biggest return, doesn't really care. We call him the sly, high, and dry screening process. But to keep in mind some of the obligations and what we're looking at, the rental application process, credit checks, screening fees, which is what we'll talk about. Generally, you've paid it if you've been a tenant, or you may charge a potential tenant fees. There's limitations on that. Again, also part of your plan is your rental terms. You want to have that ahead of time, and ideally have your rental agreement already prepared regarding what terms and the full understanding of what you'll have in writing between yourself and your tenants. And along those are disclosures. We'll kind of summarize and discuss that. Again, here we got Bob. He's talking about his rental applications. He doesn't really do anything. He just kind of goes by the seat of his pants, his gut, as he's just trying to get a tenant he thinks might be best, but doesn't go through any kind of systematic process. So that's not what we want. So starting with the rental application, as I told you earlier, all laws regarding anti-discrimination or consumer laws are starting from the beginning all the way to the, even the agreement. So keep that in mind. So that also starts with the rental application. To our left, we have Bob's application, and to our right, just a garden variety rental application. So this is an exaggerated version, but Bob has both sort of or specific discriminatory and some things that are sort of hinting or underlying to determine the right tenant. Influential friends, watch brand, yacht club, any number of these things, religious affiliations, national origin, and then he sort of doesn't pay any attention to the things that we need to know. What do we know about the previous tenancy of the potential applicant? Credit checks. We'll talk soon about disclosures. You're going to want to, there's going to be notices you're going to need to get to your tenants as well. Bob just really doesn't seem to get around to it. He'll just do as he pleases. And what you're going to want to do is have a neutral application. There's many forms for this, but the same application for everyone. And you want to go through the same process for everyone, just so later it doesn't say or show that you were somehow treating one group or individual differently from anyone else. So just by a side-by-side comparison, Bob's sort of misguided application, kind of well-focused. He's just keying on things he might see or think about might show someone an ability to pay rather than actually looking at their actual ability to pay regarding their employment history. And many of his requirements are discriminatory, probing someone's personal life or income source. He's not actually doing any financial vetting regarding looking at, is someone working, looking at a pay stub, those things that are permitted, or any actual background check. So here on your right, you want to have a standard application and process that applies to everyone, whether it's authorization or background checks, emergency contacts if you can't get a hold of your potential tenant or they've already started and they don't move in. But these are all things that need to be standard, and avoiding anything that could be overly personal that is not really relevant to their ability to be a good tenant and is not really related to their ability to pay either. One thing that's common, screening fees. Bob doesn't really follow any of the rules. It's just sort of money he collects, but there are many requirements and governing rules regarding the collection and handling of a screening fee. So a screening fee is you might charge a potential tenant upon accepting their application, and there's a cap. It's $30, and you have to think about it in the sense that you're taking money, so now you have to account for it. You're going to have to give a receipt depending on how much of that is used of the potential tenant. So this will apply to if you're going to be using it to purchase a credit application, credit check, or background check from a potential tenant, and you're going to have to give a receipt for that. There's a special rule, for example, if you taking a fee from someone and there's no unit actually available in the place. So you need to get their consent for that and refund the money. Obviously, you can't take someone's money and be unjustly enriched if you're unable to actually provide them with a unit. And costs, like any part of this process, have to be equal among all parties. Also think about that if you're taking money and you're not following all the rules for screening fees, it may not be considered legally a screening fee, more like either outside or, if they become your tenant, part of a deposit fee. So you either follow all the rules and then refund if necessary, or if you're taking this money, it might be considered part of a security deposit, and you'll have to use that later if the tenant actually, or if this potential applicant becomes your tenant. So here we are, Bob. For his rental agreements, I write my own rules. He doesn't really take any special care or thought or discuss this with any professionals or either attorney or taking care to determine what terms he has. He just sort of puts them together as he sees fit, which is extremely bad and a very common problem I see among landlords. So I call this the Bob's DIY lease disaster. So this means do it yourself. You really don't want to do that. I would avoid adding your own terms or writing your own agreement. Not that you have to be a lawyer to write a contract or a lease, but you have training in that. But you may write in such a way that what you're writing is vague or unclear. And the way the law is, if you're the one drafting it, it's going to be interpreted against you later. So I would use a professional lease. Association of Realtors have one. Different organizations have them that have tried and trusted language that you need to use, as opposed to adding a term. I see it often. For example, someone writing their own contract will not have a clear identification of what's being rented. So for example, let's say you're renting someone a room and you don't write that on the agreement. You just put the whole house. So then it comes later if you're limiting them or what they can access, or they're not able to use other rooms and they're trying to use that for storage or something like that, which is common. They could say, well, look, you wrote the full address here. I have access to the whole house. So you need to specify that. When they're paying rent, the day, and monthly. Also, who are the parties? Who's going to be there at your unit? We talked earlier about that with the blind bargain. Without an agreement or clear idea, who's going to be there? Obviously, we might have individuals or husband and wife or families. If you're not clear, they might bring in other individuals. That wouldn't be a breach because you didn't have a clear idea of what it is, who was going to be the authorized participants and residents of your rental agreement. Now, the worst case is verbal agreement, which is pretty common, especially among family, or sometimes you might know someone, or you're just not following good business sense. That's really a poor way to go because you can't enforce certain covenants outside of rent if you don't have it in writing. And then later, when you're trying to enforce the agreement, even rent, if it's not clear, you have to prove it in other ways regarding showing what they paid. And many times these landlords or property management, generally landlords in that sense that are mom and pop or someone renting out their own house or room, they don't keep receipts or give the tenants receipts showing the rent. And now it's not clear what rent you agreed upon. And so that creates problems for evicting a tenant. If you can't evict for non-payment if you don't know what it is or can't prove what it is they agreed to. So that's very important to have a very clear and unambiguous lease or rental agreement. Talk briefly about some terms that come up often. Here we have Bob, looks like surrounded by some very upset chimpanzees. When it comes to pets, this is also a complicated area. You generally have the ability to determine whether or not a tenant can have pets, except when you're now dealing with someone who has a service animal. There's different levels of service animals, but it could be, if a doctor says they could be permitted an animal, all the way to someone who might have a trained, seeing eye dog. But you need to be careful. And what is common is someone didn't state, someone enters the place, they don't have any pets, and later they now have a service animal. So despite not being disclosed, you're limited in your ability to discuss what the tenant can and can't do with this animal. You are permitted to, confirm that it's in fact a service animal. You can't get too involved in a tenant's medical or personal history, but you can't ask for proof. If there's a letter from a doctor, you're permitted an additional pet deposit and safety and other issues. So the animal, if you have a dog, service dog, still has to be safe for other tenants. But you need to be aware of this, and this is very common, or you'll have someone who has an animal and later says it became a service animal. And if the animal is causing damage, you have to treat that carefully. So it doesn't seem like you're discriminating against someone because they have a service animal. So here, Bob doesn't really care about disclosures, but there's certain disclosures you'll see. And when I mentioned being part of a professional organization, there's Associate of Realtors. If you know a realtor or you are one, you have access to all the disclosures, part of apartment association or any one of those groups that has the list of required disclosures, because that can affect your ability to enforce your agreement later, or damage or other concerns, or discrimination if you don't have disclosures, or risks. If, for example, not disclosing possible sex offenders on Megan's list. So this is sort of a summary of some of the disclosures that are required. We have just be aware that military bases are really only if they're near a base and there were somehow explosive used, or ammo or something that someone could obviously hurt themselves. So that's what and you'll see that in those disclosure forms. Again, also Megan's Law database, any asbestos, lead-based paint, things you need to be care of, mold, very important. You need to that also needs to be addressed. Make sure those things are addressed before you rent. But if there was mold and it was addressed, you still have to disclose that. Bed bugs is another one. And be aware that you can't also institute an eviction if there are bed bugs there, even if they're not paying rent. I've seen that, and I experienced itself in college in a tenancy, and they're very hard to get out. So you want to make sure if something like that happens, you address it immediately. Another important things to be aware of that people may not be aware of if you're just renting out your own home or renting out a rental property. If you have more than one unit and it's not separate utility, for example, gas and electric, you have to have a clear idea of how you're splitting it. So it's not arbitrary. So be aware of that. And another very important thing here in San Diego County to make many of you aware of, if you don't already know, in the city of San Diego and in Chula Vista, there are their own residential sort of tenant protection ordinances that are a combination of just cause eviction and information disclosures required to tenants. So, and they're very thorough, and it's not really necessarily easy to understand, especially the San Diego one, what your obligations are. So I would be careful if you are, even if you're experienced. I have clients who are property managers that are experienced, and everything from an offer to a tenant to move out is governed. You can't just write a letter. You have to have disclosures regarding the letter. And there's disclosures that have to be part of your rental agreement. and a guide that's like 100 pages that has to be provided. And if, for example, there are certain exemptions that are also provided under state law as well, that also have to be part of generally the single family. If you're a single family home, you have to provide that in a special addendum or notice to any new tenant. And so that has to be part of your agreement. And that's not necessarily in any form yet. There is one for the Tenant Protection Act that's statewide, but not for local. So you probably want to get help in making sure you have the right language for that. But that can complicate how you enforce your agreement later, whether your agreement's valid. But make sure that if you have a property in the city, this is not the county, but the city, San Diego or Chula Vista, you have additional obligations that aren't required of others. Okay, so we talked earlier about vetting. So it's very important. We want to look at the background, references, credit history. And so there's obligations to this, again, being fair across the board. If you're going to do a tenant background, I recommend you do it against everyone, regardless if someone looks like they might be more established or have money, or if you're doing it against a college student or a family. Again, it would look unfair if you do certain checks on some, but not others. Well, someone said real quick, let's see here, didn't quite catch the disclosure on the tenant protection laws for single family homes. I'll get to that real quick. State law, the Tenant Protection Act, Civil Code 1946.2, and the City of San Diego and Chula Vista Ordinance does have a requirement. That's the only one of the only exemptions requiring notice to a tenant if it applies. And I know the Association of Realtors have a form for that, but you don't get the benefit if you're an alienable, separate, single-family home, meaning this would apply to condominium, townhome, or just one unit on the property. It wouldn't apply to, let's say you had a home and a granny flat. If they can't be sold separately from one another, it's not a single-family home. But that one exemption has very special requirements. And so you have to provide that to the tenant in the lease, or else you don't get the benefit of it later if you're going to be evicting a tenant and use that. All right, we have some of Bob's background blunders. He doesn't seem to really follow any of the rules. Again, going back to his sort of the rather absurd checklist and application. That's not how you want to approach it. So again, you want to have clear notes and records of everything you do, who you contact, any references, any credit check, any type of selection process is going to be consistent across the board. And that'll also including any kind of rejection, because a tenant who was rejected is upset later and claims that you didn't follow your own rules or were discriminatory. You need to show what you do is consistent and why you rejected them. If you don't have any records, or you're just following your gut and you're not have any kind of process, then you won't be able to show that later. You'll have a hard time producing records to show you had a fair and accurate process. So again, diligence. Never make assumptions on a tenant. You're going to want to have verification on their income, on their employment. I would follow up with that. Even among friends or references or some friend of a friend, especially, I see many problems in those categories. It's not what was represented because you didn't bother checking. Meeting people is fine, but you still want to follow up, check, verify. You're allowed to get pay stubs and documentation of someone's employment. And, you got to also check, can this person, you're allowed to see if someone can afford it. You can't look at their source. So for example, you can't say someone who might be getting money from a government source as a limitation, but if they have the ability to pay it, that's what matters, not where that money is coming from. Also, I might go a little fast, make sure we get through everything before the end. But one thing to be aware of is when you're selecting tenants, it's also think about the information you're getting from others, whether you're talking to a potential landlord. You got to make sure that if you're asking something, that it doesn't go into a category of something that's inappropriate, language or where they're getting their money from, or the Section 8 or something that's inappropriate. And also another thing to be aware of is it is also very good to talk to a private or previous landlord, but sometimes they may or may not tell the truth because they might trying to be getting rid of a tenant. And so you need to do your due diligence just to make sure that you in fact can, they are a good match and can pay your rent. So you are allowed to do a fair process, but you just got to make sure you follow that. You're allowed to do a background check, check the court records, mention that later. Was this person evicted? There's agencies that do that for you. There are limitations on court records you can access, meaning if someone was evicted, but they had a agreement with the landlord to what they call mask it, you won't see it. But in that sense, you may not be aware, but you could still look if such a thing exists, just to make you aware. But again, you have to think broadly of the rules that apply before you decide to ask to either solicit, whether you're verifying information or soliciting it, that it's fair. You can't go into their personal life, even if you're religious or you might want someone who has a similar, that's not something you're permitted to ask. Just some quick overbroad or some points here. You're allowed to have income standards, but they have to be reasonable regarding who you're selecting. Again, source is not something you're allowed to evaluate. There's not but their ability, but not the source of their income. And you're, again, obviously you want someone's ability to pay, but for a business sense and also fairness, you don't want to be too exclusive, excluding, or else you might exclude otherwise good tenants. I mean, obviously you still want them to be able to afford your unit and not default later, but just keep that in mind. So again, another important thing, credit checks, and there's different types of credit checks. Bob's not a fan of following the rules regarding credit checks, which is, can be complicated. There's different agencies that do that for you, but you want to make sure that you understand that there's two different overbroad, or there's Consumer Credit Reporting Agency Act, Investigative Consumer Reporting Agency Act. If it's just for the credit, you generally, you don't have to get disclosures. But if you're getting anything beyond just credit and it's sort of their character, there's disclosures you have to provide them within 3 business days of making the request, and you have to share that with the tenant. And these are very important. If you don't follow these rules, then that could affect your complying with this, and these could be a breach under both state and federal law and the Fair Reporting Act. So just keep in mind that if you're, a good idea is just to, if you're doing an investigation and it covers both credit and background characteristics, that you in fact, let's see, okay, I'll get to that later. If you're doing character and background, that you're able to provide the right disclosures. I would err on the side of disclosing, even if it doesn't appear to. And again, I would follow agencies that do that, and that make sure you follow all those rules. And that also, that just be aware if you're using any kind of agency or organization that does a credit or background, that if they don't follow it, you're held to the standard because you're the one using it for the tenant. So you have to be aware of the rules as well. Again, going back to the background, you're allowed to look at court records, do a due diligence. That includes their bank. You can get verifications that they have the money to pay. Again, you can't look at how they get paid. You can look at court records, but you also have to make sure that if you're going to do anything beyond that, or look into the criminal background, or do a credit check or background investigation, that if you're going to get this information, you follow the rules and give the right disclosures to all the tenants, or you could be seen as possibly discriminatory or a violation of federal rules, which have significant consequences. Again, documentation is key across all part of the later. Do appreciate the questions. You're allowed to, if you want to type in a question now, I'll get to it at the end, but you could type it so you don't forget, and I'll try to get through them. Throughout the process, and if you're rejecting a potential tenant, just make sure that you have your records. Bob has no records. He's just haphazardly going through the process. But you want to have detailed notes and records that you gave all disclosures or required information to potential applicants. For example, if a applicant is denied due to a credit report, then you do have an obligation to provide them with the reason. They have a right to get the report. So if that's a reason, you got to make sure you follow through and just don't omit that or ignore it, because then the tenant later can claim that you were not following the rules, and that can get you into trouble. So looking into the, I call the parallel universe, we have the good landlord, the good Bob versus the bad Bob. From the beginning, you want to have a well-defined plan, comprehensive and fair process, objective criteria, and that you want to have the check mark showing that you did follow that throughout the process. And that also includes any protocols for credit reports, etc., that you follow them to the T. You're going to want to have, there's software too, if you're not using a property management, but and a note on that, even if you're using a property management, you want to make sure they're following the rules, because as the owner, you're still liable. But if you're doing this yourself, you want to make sure that you, in fact, follow the rules and keep the records. You can keep it digitally, but you got to make sure they're kept, and at least kept for, I would keep them indefinitely, at least digital, in case there's an issue later. Or a government investigation, not just by the tenant. Because remember, when I talked earlier about some of these overlapping laws, there's also not just by the tenant themselves might have a right of a claim or cause of action, but the government agency does have a right to investigate, and they can request rules. Their powers are well beyond what a regular tenant can do. So just remember that when you're keeping your records. So wrapping up here, again, rental plan, legal inclusive advertising. You want to have your inclusive and compliant rental application. Make sure it's fair. Make sure that what you're following are fair and valid, and you're not discriminating, even if you don't think you might. Be careful if you're limiting on a characteristic or aspect of someone other than the property itself. Why are you doing that? If you want a senior facility, or you have to make sure that you have a facility first before you advertise for over, let's say, 55 or something like that. Make sure you have a clear agreement. Make sure you have all of your disclosures and comprehensive record keeping. So again, we want Bob to be a beacon of light. Here we have very sad Bob because he didn't follow these things. Now he's not looking as happy or cheery as he was earlier. and many lawsuits and very unhappy tenants and potential tenants. Okay, questions. So I could start, go ahead and send your questions. Bob may not want them, but I'm willing to go through them. Let's see here.
Yeah, we've got a few pending here.
Let's see, it can go here. Let's see, one here says AB 1033 now allows ADUs to be sold separately from the property. That's true. Does that mean both ADUs and the SFR are now exempt from the tenant protection laws? So there is a new law that does allow someone to possibly sell or rent different parts of their property in that sense, because they're trying to address the housing crisis. But just note that this is new and there's many requirements for it, and it's not automatic yet. So if that's going to be permitted, each specific city or entity has to permit it. So for example, the city of San Diego would have to have their own ordinance that sets requirements for allowing you to sell your ADU from your home. So that would also be statewide, and so that would address any of the other limits. But you got to make sure that you follow that there is an ordinance that clarifies that in the area where you're at. So it's not automatic. Let's see, others. Can a landlord refuse to accept a third-party payer who pays, as with some disabled persons? So generally not. You also may want a cosigner, but I would be careful about rejecting third-party payments. We didn't get into that, but generally you can't just say no, especially if someone has a disability. Let's see, can criminal history be an element of refusal to rent? So that's going to depend on where you got this from. Do you have clarity on where that's from? Did you do an investigation? Were they accused? Were they actually tried? But I would make sure that you verify this before you just reject someone outright. Let's see here. We have rent control, disclosure, and the exemption for single-family condos. If the disclosure is not given before you move in, is it waived until the lease ends, or is it curable with a 90-day notice? Okay, so there is the Tenant Protection Act, which is statewide, which came out in 2020, and that had limitations on when the lease began and when a notice can be provided. Initially, it may, but was not required to be in the lease. You can provide the notice in other ways. But at this point, you need to have this as part of your lease. And when you say a 30-90 day, if you have a fixed term lease, that's different from a month to month. You can modify a month to month agreement by giving notice to change in terms, but a lease can't be modified in that sense because you already have them fixed, which is why you wanted a lease and a fixed tenant. So anything new, any new laws that come out, you could possibly add, but not previous ones you ignored or didn't include. And that also, just be aware, that also includes not checking a box. So for example, I've seen this common. There are many people who are renting to someone, they have the right form, and it's an addendum about let's say the Tenant Protection Act, but they didn't check the box that said the single family alienable separate exemption applied. They just forgot it. So you didn't check it, even if it's there, it doesn't apply. So make sure you read what it is you're including. And also that, just very important, that's going to apply to reasons for eviction. If you're excluded from the, let's say, Tenant Protection Act or local ordinance, you're now governed by sort of the default state law, which has many more, I would say, options or room regarding eviction, and other than the required just cause, which now limits your ability to evict someone. Let's see. Let's see here. I'll get to the first one and I'll come back to the property
And if
ask.
I could jump in real quick,
Sure.
Joshua, it is 1 o'clock. So if there's anyone who has to leave, that's fine. And then anyone who wants to hang out for a couple more questions, feel free.
Sure. I'll stay a few minutes if there's anyone else who wants to ask questions or however long you want to keep the presentation going. Let's see, I moved to San Diego. Let's see if I can extend. I moved to San Diego half a year and a half, despite raising the budget. No one rented me. So I guess someone obviously the ability to pay rent a year ahead. I mean, that's pretty extreme. I rarely see something like that. I see a few months, but I don't see that often, especially when you said modest condo or home. So I'm not sure if you want to clarify what you're concerned about or if you've seen them go awry. But I rarely see someone able to pay an entire, except for in college areas, you might have someone whose parent is paying for the entire year for their student, but I rarely see that. If you want to clarify what your question, anything further, let's see here. Please give examples of how a landlord may improperly ask for origin of income. So you can't ask, or if they're getting money from, let's say, or where they're getting their money from, other than verifying their employment, their bank account, or if they have a cosigner, you're allowed to see what the cosigner, check the credit of a cosigner. But if someone's, let's say, Section 8 and they're getting money from the government, you're not allowed to ask where they get their money from. And so that violates numerous federal and state fair employment and housing, and then the FEHA, the California version as well. So just know you can verify their ability to pay, but not where they're getting their money from, because most likely that could lead to a claim of discrimination. Okay, any other questions?
Okay, I think that's all we have. So why don't we wrap it up now? We did start a little bit late, so I think we're right at about the hour mark now. Thank you, everybody, for being patient at the beginning with us and for hanging in with us. And thank you so much, Joshua, for the presentation.
Sure.
There's obviously a lot to this topic. You could probably go on for another hour.
Yes.
Probably also a lot more questions that could be asked. So maybe we'll have you back again sometime to expand on this. But again, thank you, everybody. And be looking out for the CLE certificates by email this afternoon.
Thank you. Thank you, everyone, for attending.